So welcome to our webinar on the JobKeeper payments provisions, where we'll be going through the rules that were set out yesterday by the Treasury on the JobKeeper payment subsidy scheme. My name is Alexis Kokinos. I'm a tax partner in our tax consulting division, and I work in the National Tax Group. We've been heavily involved in consultation and working on a number of the stimulus package measures, and we're pleased to be able to present this to you to try to provide some further detail around the JobKeeper payment subsidy scheme. Obviously, these are unprecedented times in terms of what we're facing at the moment, and there are a lot of businesses that are struggling to make it through. I hope everyone on this webinar is doing well, and that you are managing during this process. I hope you're able to obtain something through this webinar that might be able to assist you get through this process. We have over 1,000 participants, and unfortunately that was the maximum amount that could attend. So the session is being recorded and will be available to participants after the session as well. Now, we obviously have quite a large number of people on the session, so it may not be possible to get to all the questions that are asked during the session. I have a team of members in the background who will be looking at a number of the questions that are raised during this session, and they'll also be flagging with me some questions that I might be able to respond to during the session. So apologies if I'm unable to answer all of the questions during the session. We've got a recording of all the questions, and we'll see if we're also able to respond after session if we're not able to. So just an overview of the JobKeeper payment regime, and I'm sure that most would be aware of exactly what the scheme is covering. It is the largest stimulus package that the government has ever introduced in history, in terms of it being a $130 billion package over a 6-month period. The package is aimed at eligible employers, where a subsidy will be paid to eligible employers, and what we call non-employer businesses, so self-employed, who meet a requisite decline in their turnover during the relevant period. And there's obviously a number of additional requirements to be an eligible employer, and we'll go through those today. But one of the main ones will be the decline in turnover test. Eligible employees, if they are an eligible employee and make a nomination to be an eligible employee of the eligible employer, they can then receive a subsidy of $1,500. The subsidy is payable to the employer to assist them to make payments of salary to the employee. It's $1,500 a fortnight for each of those employees. In order to access the scheme, there's a notification requirement where the employer will have to notify the commissioner, and we'll have to notify them before the end of the relevant period, and I'll go through those notification requirements during this session. So what came out yesterday? So there was 2 bills that came through. There was a number of additional bills to support the appropriation of these measures, but the 2 main bills that came through yesterday were the Coronavirus Economic Response Package Payment and Benefit Bill, and that was a bill that gave the Treasurer an ability to make rules around JobKeeper payments via legislative instruments. And so that bill itself didn't really contain any rules around JobKeeper. It just created a rule for the Treasurer to make rules. It did contain a few things around what happens if you are overpaid an amount by the government on JobKeeper. It had a lot of integrity provisions and had some record-keeping requirements within there. The other bill that came through was the Coronavirus Economic Response Package Omnibus Bill, and that included a number of consequential amendments to the Fair Work Act and other technical amendments to other bills. I will not be covering the Fair Work Act amendments through this, but you absolutely should be aware of what has occurred in the Fair Work Act. There are 1 or 2 items I will cover, including some requirements that the employer may be required to pass on the JobKeeper payment to all eligible employees by the requisite period. So I will touch on some of those changes in the Fair Work Act during this session as well. Finally, and the most important item, is the Coronavirus Economic Response Package Payments and Benefit Rules 2020 Exposure Draft. So this is the rules that were developed by the Treasurer. They were developed in draft and released yesterday in draft. They were released in draft for half the day, and then they were removed from the Treasury website during the day. And the response we had was that there was negotiations with respect to certain parts of the rules, so they were still modifying them as of yesterday. I will be focusing on those rules. This is a detailed session. Hopefully we'll answer a lot of questions and we'll go through the provisions in quite a lot of detail. Our aim is to give you enough information so that you'll be able to walk away with the copy of the slides and be able to understand how these rules apply to your business. There is a lot of uncertainty around the application of rules. Obviously, they only came out yesterday. There's some ambiguous drafting, some drafting errors, and there are a lot of questions that still need to be answered. No explanatory material around it. So there will be statements that I make today that over the next month will be clarified by Treasury and ATO, and they could be very well different to what I state today in terms of how interpretations are taken. So I will encourage you to continually check in with your advisor, make sure that you understand what the provisions are, and be updated on anything that may change, because one, these are only draft, and when they become final, they may change again, and interpretations may change. So I'll say that as a caveat to the rest of the presentation, that although I may state certain things during this session, you just need to be mindful that these are very new provisions. They are in draft and they are subject to interpretation and change. Okay, so we're going to cover four main areas today. And the first is the eligibility requirements for business entities. And that will be the main part of our discussion. We'll cover mainly what a business would need to do to be eligible for the JobKeeper payment subsidy. We will also cover eligibility for self-employed businesses, so how they may otherwise also be eligible for a payment for a business participant. We are going to touch on the integrity provisions that are contained in the bill, and there are a substantial number of integrity provisions that you need to be aware of. Finally, we're going to end with the key action items, or the things that we think you need to be thinking of straight away and need to be dealing with as soon as possible. The first section is the eligibility for business entities. So the way these provisions work is that they look at your eligibility for what they call a JobKeeper fortnight. And on many of the tests, you need to pass the eligibility test on or before the last day of a JobKeeper fortnight. Now, JobKeeper fortnights are predominantly all fortnights ending after or starting or commencing from March the 30th and ending on the 27th of September. Now, there are some special rules for the first two fortnights, which will end on the 12th of April and the 26th of April. And so we'll call them the first two JobKeeper fortnight periods. From there on, we have each other fortnight, which goes on for the remainder of the periods. And there's 13 of these JobKeeper fortnight periods over the 6-month period for which this scheme applies. Now, just some basic maths there, that if an employee qualifies for JobKeeper payments for all of the 13 payments, it will be $1,500 per payment. So it is $19,500 that the employer will receive per employee. So it is quite a substantial subsidy with respect to the employees. As you'll also see there, that the end of each fortnight is on a Sunday. So there are a number of challenges around meeting requirements on a Sunday. The Tax Admin Act, when you have to lodge a form, does give you till the next business day to lodge forms. So where there's form requirements, you may have until the Monday to lodge those forms. However, on some of the conditions that we go through, there's payment requirements that need to be made by that period, and we haven't seen anything at this stage as to whether there will be an extension to the Monday or the business day for those requirements. So when will the Commissioner pay an amount to an employer? So to start off with, the amount of the payment, as I mentioned, is $1,500 for each individual that is eligible. Now, as you'll see throughout this session, I'm referring to sections. These are the sections contained in the rules. So once you have a copy of those, you can obviously track each of those statements down and look at the requirements yourself after the session. The legislative, the draft rule document is not a long document. It's 21 pages, so it is fairly easy to walk through some of these rules. So there's references there for your use. So when must the payment be made? So the commissioner has to pay the JobKeeper payment if the commissioner is satisfied that an entity is entitled. So the commissioner needs to be satisfied that you're entitled, which means you need to self-assess and provide all the information to the commissioner in an approved form. And we'll go through that information that needs to be lodged with the commissioner for him to be satisfied. Now, there's an exception to that. The first fortnight is falling this Sunday, and the second fortnight falls on the 26th of April, and we don't have rules that are final rules at this stage. So unfortunately, he may not be able to have satisfaction of the ability to satisfy those rules. The commissioner may not be able to satisfy himself for those first 2 fortnights. However, he's allowed to still make payments even though he has not satisfied himself of that. Now, that doesn't mean that the parties will be eligible for the payments if their information they have provided is incorrect. So once the commissioner is satisfied that the entity is eligible, then the commissioner needs to make a payment. The rule for payments are that the commissioner needs to make the payment no later than the later of 2 times, 14 days after the end of the month in which the fortnight ends, and 14 days after the commissioner is satisfied of the entitlements. So if we looked at April, the last fortnight ends on the 26th of April. So then 14 days after the end of the month will be the 14th of May. And so we would expect that the first payments that are going to come for April will be payable early May up to the 14th of May, hoping that the commissioner will satisfy himself of the entitlements within that period. Now, one of the key things here is you'll see that obviously we will have a requirement to make a payment, and we will touch on this a little bit later, but you may not receive an amount back from the commissioner until the 14th of May. And so there may be some shorter term funding requirements for your business if you are to make job seeker payments in the meantime. And so I will touch on the exact requirements for payment as we go through this session, but just mindful that the commissioner is paying the amount in a delayed manner. So it is coming after the fortnight, so after the month in which the fortnights have occurred. The 5 basic requirements for an employer to be eligible to receive a payment are on this slide. The first requirement is that an entity who is an employer is eligible on or before the end of the fortnight. So that requires you to go through what we say is the eligibility requirements, which we'll cover on another slide. The relevant individual who you're receiving the payment for must be an eligible employee of the employer for the fortnight. And we'll touch on exactly what that means as well. The employer must satisfy the wage payment conditions, and that's amount and timing. And the employer has satisfied notification requirements by the due time, and we'll touch on what those actual requirements are, what you need to notify the commissioner and when, and the employer has provided information to the commissioner in approved form. So each one of those tests we're going to go through in a bit of detail, and I just note at the end there that the employer has to determine eligibility for each fortnight. Now, if you're in the scheme, there's also another condition that you are in. Once you've elected to be in the subsidy scheme, you're in there until you elect to come out of the scheme. Now, once again, we go through the wage payment conditions. It may become clearer as to why a person may elect out of the scheme. But you are once you've elected in, you are in the scheme, or until you elect to be out of the scheme. So who is an employer? Who are we testing with respect to the decline in turnover? So this has been a bit of a changing beast over the last couple of weeks, but the rules provided clarity around exactly who we're testing. The rules clarify that it is on an entity by entity basis. So you look at a single entity and you look at that entity in terms of it being an employer. There are no grouping provisions. So you're not looking at the entity and related parties when you're looking at has my turnover declined. If that entity is part of a GST group, you would need to disaggregate that entity and make adjustments for that entity so you can account for it as if it was a separate entity. And if the entity sits inside a tax consolidated group, the single entity rule does not apply. And again, you treat that entity as if it was separate from the tax consolidated group. So you treat an entity as if it is separate for the purpose of the decline in turnover test. Now that's a little bit different for determining whether your turnover is over $1 billion or under $1 billion, because there is a grouping rule for that. Though for the majority who are under $1 billion, that aggregation rule won't be relevant. So for the purpose of the decline in turnover test, it is a non-aggregated rule. So once you've identified that entity, there are two main tests that you need to satisfy. The first is the entity on the 1st of March must either carry on a business in Australia or be a not-for-profit entity that pursues its objectives principally in Australia. So those are the two types of entities. So foreign entities cannot access this scheme. And the critical test is the entity must satisfy the decline in turnover test at or before the relevant time. And we're talking about that at or before the relevant time being the end of the fortnight that you're looking at. There are a number of other additional tests that likely won't apply to the majority of entities. The entity can't have the major banking levy imposed, and there's only 5, we understand, financial institutions that have that imposed. It can't be a government entity or wholly owned subsidiary of such, so government schools would be out through that rule. It can't be an entity with sovereign, can't be a sovereign entity, so foreign government-owned entities that are sovereign entities would not otherwise qualify. It can't be an entity that has a liquidator or provisional liquidator that's been appointed, and it can't have a trustee in bankruptcy that's been appointed. Okay, so the main test that everyone critically needs to be aware of, which is the decline in turnover test. So that's contained as a starting point in section 8. Now, what this test looks to do is it looks at your projected GST turnover during a relevant period, and we'll talk about what a relevant period means. And that projected turnover needs to fall short of your current GST turnover for a comparison period. Now, these are all defined terms, and we will cover exactly what each of those mean. And that projected turnover needs to fall short by a percentage, and that amount needs to exceed the specified percentage. So projected GST turnover is generally going to be the amount that you're estimating to be your turnover for a period, and the period will be monthly or quarterly, and we'll go through that part in detail. So April, for example, we could do a projection or an estimation, and that would be our projected GST turnover. What is your estimated turnover for April? Current GST turnover for a comparison period would be the same period 12 months ago, so April 2019. And comparing those two, you would need to fall short by 30% in order to just say meet the specified percentage if you are less than $1 billion turnover. So the relevant percentages for different entities are those contained in the table. So if your aggregated turnover is less than 1 billion, your threshold is 30%. Greater than 1 billion, your threshold is 50%. And if you're an ACNC registered charity, the threshold is 15%, 15% irrespective of turnover. Now, there's an exclusion from the registered charities being certain higher education providers and schools, which are excluded from that, and they would need to fall back to the ordinary rules under 30% and 50%. So what is a relevant period that is being tested? So in any fortnight that you are in, you're able to do 2 tests in terms of projected turnover. You're allowed to look at the projected turnover for a month the current month to which the fortnight is in, and you're allowed to look at the quarter to which the fortnight's in. So if we took the month of April would be a month, and you could do a projected turnover for April. And April would also sit in the June quarter, and you could also project your turnover for the June quarter, which means that you can compare those two periods independently to last year to determine whether you meet the 30% decline test. Now, what that's doing is trying to eliminate issues around cyclical behaviour. For example, your April month may be exactly the same as last year. However, you may have periods in May and June that are expected to drop off substantially. So although you may not satisfy it if you tested month to month, if you are estimating your quarter will be down by 30%, then for this fortnight, you could potentially qualify. Now, on that exactly, I will go through an example to demonstrate how that calculation will work. But before I do that, the key thing is just to understand what exactly is GST turnover. So the test is looking at projected GST turnover, and that comes out of section 188.20 of the GST Act. Now, I've put up the definition in terms of what projected GST turnover is. And that's word for word from the legislation. Your projected GST turnover at a time during a particular period is the sum of the supplies that you've made. That does include taxable and GST-free supplies, or is likely to make during the period. Now, interestingly, you need to be aware there that it does not include input tax supplies. So, for example, if you are a finance entity and you derive interest income, then your GST turnover would not include your interest income. But if you were charging fees for establishing deals or other things where you have made taxable supplies, then those things would be taken into account in this test. If you provide residential rent, again, that may be input tax that may be excluded from the projected GST turnover test. So it is pretty critical to understand exactly which supplies are taxable and GST free and what you're projecting those to be through the month. So the test is what have you made and what are you likely to make during that period? And when you're breaking that test up, obviously we're sitting here on the 9th of April. And in the 9th of April, we have made supplies for a period, i.e. 9 days, and we are likely to make some supplies for the remainder period. So to get guidance on how to apply that rule, there's a GST ruling. It's GSTR 2001/7, which provides the meaning of GST turnover. And there's 3 main paragraphs which I want to share. The first is at paragraph 16 of that ruling. What the Commissioner has required in analysing that test is that a person needs to make an objective assessment in terms of its turnover and what it's likely to make. And it must be one that a reasonable person could be expected to arrive at, having regard to the facts and circumstances which apply to the enterprise at the relevant time. And the Commissioner will accept your assessment of these turnovers unless he has reason to believe that your assessment was not reasonable. So as a starting point, you obviously need to make a reasonable assessment. Now, one of the key questions here would be, how can one possibly make a reasonable assessment in these challenging times where what we have is unprecedented and nothing that we can compare to, and people don't know what's going to happen going forward. So there's further guidance in the ruling. The ATO then say the expressions likely to make and likely to be made mean on the balance of probabilities it can be predicated the supply is more likely than not to be made. Again, that in itself seems like it may be a difficult test. So the final paragraph, which is important, is when a supply is made, it is determined in each case by reference to the terms of a particular contract, if applicable, and the nature of the supply. The purpose of calculating supply is likely to be made. We'll accept the calculation based on a bona fide business plan, accounting budget, or some other reasonable estimate. And I think this is the critical paragraph in the ruling. The ATO, when they go through these examples, they do look at exactly what contracts are on foot and what you may otherwise be working on at the moment, what your expectation is around servicing those, billing, how that may impact your business in terms of your production, and they would accept a bona fide accounting budget or other reasonable estimate, provided it is bona fide. And in our view, it would be quite critical for businesses to go through that information and do it properly in terms of their estimation in order to ensure that they are within the confines of the GST ruling on GST turnover. To give an example here, just say we've got a company, Bizco, which carries on business, employs 100 staff members. And on 11th of April 2020, Bizco makes an estimate of its projected GST turnover. So because we're in the fortnight of 11th of April, we've got basically two periods. We've got April being a month, and we've got the June quarter that we're going to do an estimate for. And so what Bizco has done is it's estimated its sales in April to be 2.3 million, and then it's estimated the remaining periods of May and June to be 2.2 million and 1.7. So it estimates its total quarter to be 6.2 million. It then goes and works out using its information what its actual GST turnover was in the comparable periods, which is there in 2019 actual, which equals 9.2 million. And then at the end of the quarter, it has actual figures, which is in the actual column. And as you can see, they've just assumed in this example, they have gone a little bit better than what they predicted. So how does this test apply in this case? So as mentioned, the turnover test period in this example is either the month of April or the quarter ending 30 June 2020. So the projected GST turnover for these periods are 2.3 million being the month of April and 6.2 million for the quarter. So we would compare 2.3 million for April against 2.5 million the prior year, and we would compare 6.2 million for the June quarter against 9.2 million in the 2019 June quarter. Our projected decline, if we are doing the comparison, would be we're only declining by 8% when we look at April, but we would decline by 32.6% if we looked at the quarter. Now, provided we meet the criteria for this being projected turnover, so meet all the criteria that was listed in the GST ruling, we would expect that this would be a bona fide estimate and that we should qualify for meeting the 30% reduction turnover threshold. Now, we do note there that the actual decline was 4% and 28.26%. So obviously we didn't actually get to 30%. We're slightly below that. Now, in some of the Treasury fact sheets, they said that there will be some leniency where there's small deviations. And although they didn't provide explanations of those rules, what we understand them to be saying is exactly what the ruling was saying. If you've made a bona fide attempt and your attempt was reasonable, that you should still be okay. So it will be critical where we don't meet the threshold in our actual figures that the Commissioner may come and question us about our actual calculations and require evidence to ensure that what we've done has been a bona fide attempt to ensure that our numbers are representative of what the projections should otherwise be. So in our view, it would be critical that we do follow the requirements of the GST ruling and that the projections have some scrutiny around those to ensure that the ATO don't come back later and say that the relevant entity doesn't qualify. And there are consequences for not qualifying when you've otherwise said you have. The ATO do have powers to have those amounts repaid back, which we'll cover a little bit later. Now we're expecting that a number of businesses may not fall into that 30% threshold as compared to the prior year. And we'll touch on a few examples as well. So the legislative instrument included a commissioner's discretion, where the commissioner may, by a legislative instrument, determine that an alternative decline in turnover test can apply to a class of entities if the commissioner is satisfied that there is not an appropriate relevant comparison period. So there's two critical things in this. Although he can do alternative tests or announce alternative tests, there needs to be a class of entities, and he has to be satisfied that there isn't an appropriate relevant comparison period for that class. So this is not a discretion that will be applied on an individual entity by entity basis. You can't apply to the commissioner and ask for that entity to be excluded. You possibly could make applications or submissions to say, here's a class of taxpayers or a class of entities that are trying to get access to it, and this is a common issue that is being faced by them. Examples that have been put forward have been startup entities. Obviously, they don't have a comparative period. Service entities, where they service other entities in the group and the turnover decline would happen to the other entity in the group. Cyclical businesses, where certain industries may have different periods, farming operations, etc., where their turnover is variable. And finally, variable business turnover businesses which aren't cyclical but may be transactional based. So those are the principles in terms of employers being eligible for the JobKeeper payment provisions. Now, I'm going to just quickly touch on some questions around the turnover test in terms of what we've been getting as questions sent to us, and I'll also just check in to see if there's any critical questions that have been raised. I can see there's a lot of questions being raised on the webinar, and I'll check in with the team to see if there's ones I might be able to respond to. So the first question I want to touch on is the first fortnight ends this Sunday. Can the eligibility test be satisfied for this first fortnightly period? Well, it will be very difficult to be able to satisfy all the requirements by this Sunday. First of all, we don't have final rules. And secondly, there's a number of things that people wouldn't have done by this Sunday. So we expect there's going to be some leniency around the first and second payment periods, because I think it will be impossible to actually satisfy these by this Sunday. If you satisfy the turnover test in one period, is it satisfied for all future periods? So this is a question that we are seeking clarity on. At the moment, the way the provisions seem to read is that once you satisfy the turnover test for the period or before that period, it would seem to suggest that you continue to satisfy that provision. Now, we think that may be anomalous in terms of if you just have for one fortnight a period where you satisfy that you would get that for all 13 fortnights. So although the reading of the provision appears to suggest it could be, we don't believe that's absolutely clear, and we are seeking clarity. So it is something that should be clarified. We do note that as these payments won't be made to employers until May, that we think for the first month it's probably not as critical an issue. So we hope that the Commissioner will clarify the test over the next coming weeks. If your turnover did not decrease from 2019 but has dropped 50% since March 2020, will I satisfy the turnover test? Unfortunately, the answer on this one is no. So for example, if your sales were not as significant last year, so just say you had $2 million of sales last April, your business grew during the year, so it's quite substantially higher this year, but you've dropped off by 50% since March. Unfortunately, you need to compare April this year with April last year. And it is not relevant that you've dropped off by 50% since March of this year. If all employees are employed by a single employment entity, and it charges a service fee, which is cost plus to a business entity in the group, will it satisfy the turnover test? So this is an interesting question. The entity being tested is the employment entity. So it might sit inside a consolidated group, it might sit outside of the consolidated group, but that is the entity being tested. And if nothing else happens and it continues to charge cost plus, it won't have a decline in turnover and it will not satisfy the test. There will be questions about whether if costs decline, if there are staff that are made redundant or are stood down, would that result in costs decreasing? Would that result in the turnover test being applied or being applied in that case? It's also questions of whether you can agree to reduce the fee to related parties. I'll talk about some of the integrity provisions later on, so you just need to be very mindful of the integrity provisions that could apply. If there is a decline in the service fee and it's directly related to the other party not being able to pay the same service fee due to COVID-19 issues, then I believe that you'd have a better chance of making those adjustments and amendments. If it is unrelated to COVID-19 and is there to try and get access to JobKeeper scheme payments, then you may fall foul of some of the integrity provisions that we talk about later. It is a bit of a watch this space, and a employment entity or service entity could fall part of one of the Commissioner's discretions, as it could be seen as a class of entity. So there might be further guidance on this too that might come out. Can I adjust intragroup charges to satisfy the turnover test? What if the adjustment reflects commercial outcomes? What if I don't have an agreement between the related parties? So this is very similar to the last question. If you are charging intragroup entities, you just need to be mindful of the integrity provisions and the justification for any of the changes. The final question I've got here is, can I continue to reassess the projected GST turnover test for each of the 6 fortnights in the June quarter? So what this is saying is, if just say in the first fortnight you don't have a decline in 30%, can you have a decline in the next fortnight, i.e. can you revise your projections by the next fortnight and then satisfy the decline turnover? And the answer is yes, it is a continually rolling test. So you can potentially satisfy in one of the later periods. Our current reading of provisions, it doesn't mean that you are necessarily backdated in terms of you start getting JobKeeper payments for earlier periods of that quarter. Our initial view, or our view at the moment, is that the qualifications is on a fortnight by fortnight basis. So if you don't assess the requirements in an earlier fortnight, then you can't go backwards. Now that obviously isn't absolutely clear, and we'll be seeking clarity on that over the next coming weeks. Okay, so after determining who is an eligible employer, the next question is who's an eligible employee. So we've got 8 tests for eligible employees. The first is that the person needs to be employed at any time during the fortnight. So if you're employed at least one day during the fortnight, you'll get through the first test. The person needs to be employed by the employer as at the 1st of March 2020. Again, you'll note that's a weekend. So I understand that the first day in March was either the 2nd or 3rd of March, I believe. So 2nd of March was the first day of a working day, potentially for a number of people. Sunday could have been a working day. So it is questionable whether, if you signed a contract before that date, whether you would be employed by the employers at that date. So although it's probably not a lot of people, there is a question of transition there for those ones that signed pre that date. You need to be at least 16 years old as at 1st of March 2020. So this may affect a number of casuals. They may turn 16 after that date, but they will not qualify for JobKeeper payment at all if they weren't 16 at 1st of March. So it applies to full-time, part-time, and long-term casual employers. So the way the legislation, so that's what has been raised in terms of the types of employment. So the actual provisions only refer to an employee who's not casual, and then refer to what we call a long-term casual employee. And The one that has had a bit of debate has been, what's the definition of a long-term casual employee? And essentially that needs to be a person who on the 1st of March, they were a casual, and they need to be an individual that's been employed by the entity on a regular and systematic basis during the period of 12 months that ended on the 1st of March 2020. So it needs to be someone who has been on a regular and systematic basis a employee of that entity. So it may cut out a number of casual employees who may not have been employed 12 months prior, i.e. 1st of March 2019. There's some Australian linkage requirements in terms of who it applies to. Generally speaking, Australian citizens and certain visa holders who are Australian residents. Generally, these are 444 visa holders. We have had some questions about 189 visa holders, and we understand that to be generally in terms of New Zealand visa holders, that to become a 189 visa holder, one of those requirements is being a 444 visa holder. So we haven't got an answer on the 189 visas at this stage, but we'll look to clarify that. So if you're receiving paid parental leave, it can't overlap the payment period, and you can't be paying a dad or partner pay at the same time as well. You won't qualify if you get those. If you're receiving workers' compensation, you can't be totally incapacitated, i.e. you can't work. So if you're at home, can't work, and receiving workers' comp, you won't receive JobKeeper payment. And then the individual has to give a nomination notice to the employer, and it does need to put in the requirements that does satisfy these things to the employer in order to state that they're eligible. The individual can only select one employer to receive the JobKeeper payment as well. Now, there's one special rule which covers if there's been a change of employer and you're looking at the 12-month casual rule, you can still comply with that if the new employer is wholly owned by the old employer. So a very limited change of employer rule. So the third condition is that you need to meet what we call the wage payment conditions. Now, the wage payment condition, the way it's come out in the Act is, I believe, very different to what had been announced previously. And it's probably once people go through this, though, I think personally it may be a bit of a shock at the start in terms of how they've done this. What they've said is you need to provide the following amounts that must equal or exceed $1,500 on that fortnightly period. The first item is you need to pay salary, wages, commissions, bonuses, allowances, and it needs to be paid in the actual fortnight. On top of that, they will include any payments that you made for withholding taxes in respect of those payments. So if you've withheld on their PAYG, they will add that to the payments of cash that you have made. They'll add to that any salary sacrifice superannuation amounts that you have agreed to pay on behalf of the employee. This is not SGC payments, this is just salary sacrifice amounts. And they will also include other amounts that are applied for on behalf of the employee or by way of an agreement by that employee. So for example, if the employee has agreed to allocate $100 of their salary for fringe benefits purposes and they've reduced their salary by that amount, that equivalent amount should hopefully be applied in this calculation. Now, there is a special rule that can allow amounts to be allocated to different periods and events and the Commissioner can take events to have happened in a different period. Now, it's not exactly clear on the wording how that applies, but we believe that it's to hopefully overcome some of the stringent rules that are contained here. For example, as you can see, the salary and wages need to be paid in the fortnight, and the fortnight ends on this Sunday, which is the 12th of April. And for example, if you paid the wages on the 13th, would you miss out? So the question would be, by paying it one day late, have you paid in the fortnight? So the answer would be no, it wouldn't be paid in that period. So therefore, that payment would not be counted potentially. There's a question of whether this special rule can allow the Commissioner to allow that payment to have happened in the previous fortnight. It's going to be a very important rule. I just got to also mention here that if you do not pay an amount, there is a requirement of Fair Work Act that says if you're an eligible employer and you've elected into the JobKeeper payment rules, then you must pay the amount which is the wage payment amount to employees by the end of the fortnight. So there is actually a requirement in that act to make payments, and there can be civil penalties for not complying with that. And so I'll explain how that may be detrimental to some businesses when they elect into these provisions. So just be mindful, that is section 789GA, the amendment to that provision, which is contained in the coronavirus bill that was also passed through yesterday. So to provide an example of this, assume that we paid cash to the employee, so net cash in their bank of $1,200, and we paid that before the end of the relevant fortnight. Assume that we have withheld $260 for that employee, and we will include that in the next activity statement as a contribution to PAYGW withholding on that wage payment. Assume that we're salary sacrificing $90 for that employee on a fortnightly basis, and assume that the employee salary has been reduced by $50 because we're applying $50 against some fringe benefits, for example, like half fringe benefit or something else for that employee. What this requires you to do is add all those amounts up, and you must ensure that that is equal to $1,500. So in this case, because that was equal to $1,600, we would meet the wage payment condition for that employee, and then technically satisfy the requirements to be paid the JobKeeper payment amount from the ATO. Okay, so just going through some general questions we've received, and I'll also again check in with the team to see if there's been some other questions that I need to address here. So first is, does the payment strictly need to be made by the end of the fortnight? And our answer at the moment is yes, it does need to be paid at or before the end of the fortnight. The two requirements are to get access to the wage payment. All right, to get access to the JobKeeper subsidy, and also to comply with the Fair Work Act. Now, the Fair Work Act still provides an obligation even if you haven't paid the amount and don't qualify for the JobKeeper. The Fair Work Act also says that it needs to be paid for every eligible employee as well. So it appears that you can't pick and choose which employees get access to this too, is how we're reading the provisions at this moment. So what happens if the sum of payments equals $1,499 because of a rounding error? Unfortunately, it's below $1,500. So if you missed out by $1, you don't qualify for a JobKeeper payment, is how the provisions read. As I mentioned, the Commissioner has a discretion to be able to allocate things to other periods, and you may be able to make a catch-up dollar payment to comply. But at this stage, the way the provisions read, and without a Commissioner's discretion, you could miss out on receiving it if you are under the total amount for that employee. So if the payment comprises of wages, i.e. the first bucket, why isn't there an SGC, superannuation guaranteed charge obligation with respect to that? So why don't you need to pay additional superannuation on that? There is no explanation for that. We believe that it could be because if there's an excess amount over and above their normal salary, that it may not constitute ordinary time earnings and may not constitute an obligation to pay superannuation on any excess component. If the $1,500 is below their ordinary salary, then you would just be paying superannuation as normal. If, for example, their ordinary salary for the fortnight was $1,400, so you've made an excess or catch-up payment of $100, then we understand that may not be ordinary times earning and therefore may not be subject to superannuation guarantee. However, we are still confirming that answer. Is there going to be payroll tax or work cover liabilities on the payments? We understand that already a number of states have come out with statements saying that they're going to exclude excess payments from payroll tax. We haven't heard anything on work cover, I believe, to date. So there may be some adjustments for either of those two, or may not become within the definition of what they pick up in those assessments. So I don't have an answer on those questions. It is a bit of watch this space for those two. If I previously paid my casuals around $200 a week, will I now need to fund an additional amount in advance, i.e. pay them $750 per week and then receive the JobKeeper payment afterwards? The answer to this question at the moment, we believe, is yes. If you wish to be a part of the JobKeeper subsidy scheme, then you would need to make the wage payment test at the end of each quarter, which means that you will have a potential funding issue for the interim period. So your wages could go up 3- or 4-fold during that interim period while you're waiting for the subsidy to come back. The Treasury, in their latest Treasury statement, said that they believe that the funding issue should hopefully be met by banks. They were saying that they believe banks were going to fund on security of the payment coming through. Now, whether that's true or not, I couldn't say that, but there will definitely be a funding requirement during that intermediary period if you have excess amounts that need to be paid. So how is the subsidy payment to be funded? Well, that is an issue for the employer to definitely work through in terms of funding requirements. I'm going to keep going. I know again that the team in the background is still going through questions that you're raising and trying to respond. There's literally hundreds of questions coming through, so it's becoming very difficult to respond to all the questions that are coming through. Again, apologies if we can't get to your question. We'll again attempt to try and come back to you as soon as possible. Moving on to the 4th and 5th tests with respect to the employer requirements. These are the notification and information requirements that need to be provided to the Commissioner. So there's 5 basic requirements. Again, I'll put all the section references there if you need to look at these any further. I expect the ATO to come out with approved forms, documents, and these will be the things that will be lodged on their website or through the system in terms of enabling access to the JobKeeper payments. So the first is you must notify the Commissioner of the employee entitlements. So essentially, the employer needs to notify the Commissioner about each employee's entitlement for the fortnight. We believe that notification process is likely to be through STP. That's what the Treasury have stated in a number of their documents. The ATO haven't come out completely and said that. Not everyone's on STP at the moment, so there might be some alternative ways of reporting. But we would expect that would be the way you would report the information to the Commissioner with respect to who is on the JobKeeper and how much is being paid to them. Then you need to notify the employee of the employee's entitlement. So within 7 days of notifying the Commissioner, you then need to notify the employee the same exact information that you've given to the Commissioner. So whether that's on their payslip, whether that's in a different format, yet to be seen, but there needs to be a notification to the employee. The next two is probably the ones that probably should have come first. They are elections to participate. So in order for this to apply, the employer needs to make an election to participate in the scheme. Now, for the first 2 fortnights, there's an extension of time. You don't need to make an election until the 26th of April, 2020. Once you make that election, you need to have notified the Commissioner by the 26th of April that you're participating in the scheme. So he's got notification of that, so he understands that you're participating in that. So obviously, the election can come after the first fortnight that has occurred already. If you don't qualify, for example, in April, or you choose not to participate in April, then for every other fortnight thereafter, you need to make the election on or before the end of the relevant fortnight. So the Commissioner needs to have that election by that time. Finally, if you qualify for a month, then there's ongoing reporting to the Commissioner. You need to, within 7 days after a month has finished, you need to give the Commissioner the actual GST turnover for the prior month, and you need to give the Commissioner your projected GST turnover for the coming month. So this is where it's going to be absolutely critical that, one, you are ensuring that you're up to date in processing all of your supplies through your system to be able to give the ATO your actual GST turnover for the prior month, and that you are in a position to project out your GST turnover because come the following month again, you would need to then provide an actual and a projected again to the Commissioner, and this will be ongoing throughout the 6-month period. Okay, so those are all the 5 requirements for eligible employers. Now, what we're going to do is just quickly touch on another category of eligibility, which is in respect of what we call business participants. These are people who can work in a business but aren't currently being paid a wage, so the owners of the business. There are special rules that allow one of those owners or participants, as they call them, to obtain access to a JobKeeper payment. Now, essentially, the requirements for the business participant is the same as what we just went through for employers. So you have essentially all of exactly the same criteria that entity needs to satisfy and go through, which is criteria 1. There are 6 other criteria that need to be satisfied in order to get this. The first is you can't be a non-profit body. The second is the individual must be an eligible business participant for the fortnight, and they are a very small class of people. So we'll touch on that on the next slide in order to get access to this. In each business, you can only nominate one of these individuals. So in terms of the owners or the self-employed persons, only one can be linked to an entity or an employer. Now, no other entity outside of the one we're looking at can be entitled to a JobKeeper payment for that individual. So if that person also is employed by another business and they're receiving JobKeeper payments in respect of that other business, then you aren't entitled to a business participant rule. There is a income requirement, that is, you must have derived some income in the 2019 income year or had a taxable supply from 1 July 2018 to 12th of March. So you need to have had some activity at least up until 12th of March. It can't be accessed by new businesses. And the entity must have had an ABN at the 12th of March 2020 or a later time as required by or allowed by the Commissioner. Okay, so who's a business participant? So there's 4 types of entities, and then there's different types of individuals that can be a business participant. So if you're a sole trader, so operating in your own name, then the individual is the business participant in that case. If you are a partner in a partnership, then the partnership can nominate one partner to be a business participant. If you have a trust that is operating a business, then the trust can nominate an adult beneficiary to be a business participant. And if you're a company, the company can nominate either one shareholder or a director. And remember, in our earlier requirements, you need to be a business entity. So this doesn't apply to a company that literally just invests as a passive investor. It does need to be a business entity that can get access to these rules. The other condition here is the individual that you nominate must not also be an employee of the business and must be actively engaged in the business carried on by the entity. So they have to be actively involved. And generally, it needs to meet all of the other requirements to be an eligible employee. So everything we went through on eligible employee needs to be satisfied by that business participant. So just some of the questions on the business participant rules. So the first question, one of the questions we received was, can the entity qualify if it has employees? The answer is yes. Any entity that has employees can get access to the JobKeeper provisions for employees and can get access to one payment for business participants. So who receives the payment of the $1,500 in respect of a business participant? The rules, I think, may have been drafted incorrectly here. They clearly state that the entity receives the payment. So if you're operating through a trust or company, it seems that that is the party that receives the payment rather than the business participant. Is there a requirement to on-pay that to the business participant? No, there doesn't seem to be any requirement to on-pay that to the business participant. So the entity seems to keep that payment on the current drafting of the rules. Again, we think this may be an error. So if the company receives the payment and then pays it to the individual who's a business participant and they're a shareholder, how will this be treated? Well, there can be some tax consequences for this. This could be treated, for example, under Division 7A as an unfranked dividend, which can be taxed at top marginal rates. Now, they may have left that there in terms of suggesting that if you had to pay that anyway to the party, that would have been fully taxable, and thus the outcome that occurs. But unfortunately, the way it currently applies, it needs to go through the company, and if the company pays that to the individual, you need to go through the normal tax consequences of a company making a payment to that type of person. So, as mentioned at the start, these provisions are going to cost about $130 billion, and due to the nature of these and self-assessment, obviously the government is concerned that there could be a number of activities where people are potentially going to try and access these provisions where they may not otherwise apply. So they do come with a substantial number of integrity provisions that could apply that you need to be aware of when going through these provisions. And I'm only going to briefly touch on these and I'll highlight the sections where they are contained. Also, I'll refer to the explanatory memorandum if you need to look at these any further. The first is the overpayment debt rule. And essentially what it says in this rule, which is contained in the Coronavirus Economic Response Package Bill, it just basically says if the entity is not entitled to the JobKeeper payment, i.e. you don't meet the qualifications, then you need to repay that amount and repay back the general interest charge on that amount for the days you've had the money. Now, in addition to that, they've included a joint and several liability rule. So they say that if you've got access to the payment and it's due to a false or misleading statement by someone else or fraud of someone else, then that other party can be jointly and severally liable. So this is, for example, an employee fills out the form saying that they can access it and that you're the only employee they're accessing it, but they've done that for 5 other employers. In that case, you may not be eligible and you may need to pay that back, but the employee will be jointly and severally liable to that. Now, this is also interesting in terms of it just talks about a statement made by any other party. So this is where I think advisors and anyone else who's also assisting with a party need to be careful, because a number of statements will be made to the Commissioner in respect of accessing these provisions, and if there's information going from other parties to the Commissioner in terms of qualification, and they're either false, misleading, or due to fraud, then that party making those statements may also be potentially joint and severally liable. So there is a very broad provision potentially here around joint and several liability for overpayment. And so all parties involved need to be very careful about the information going to the HO around estimations. There's a record keeping requirement. You basically need to keep all the records that the HO require with respect to the claim, and it's a 5-year record keeping requirement. Finally, if you enter into a contrived scheme, a scheme that's entered into for the sole or dominant purpose of being entitled to payment or increasing entitlement to the payment, then essentially you are not entitled to the payment. So they will look at what you have done. Have you done that only to get access to the JobKeeper payments and for a sole dominant purpose? And if that's the case, you will not be entitled to the arrangement. So it is for bona fide businesses that are effectively being impacted by COVID-19, where they've had the decline in turnover and therefore qualify for the provisions, is what they're intending to get to at under that test. In addition to that, they have outlined in the EM to the bill, and it's in paragraph 2.38 of the EM, the other penalties that you need to be aware of. And for false or misleading statements under the Tax Admin Act, there can be a financial additional penalty of 75% of the overpayment and potentially imprisonment for 12 months and a fine of 50 penalty units for that offence. Failure to comply with the taxation law can also receive 12 months imprisonment and 50 penalty units. Obtaining financial advantage by deception can have up to 10 years imprisonment under the criminal code. Conspiracy to defraud can also have up to 10 years under the criminal code. And obtaining financial advantage can also have imprisonment for up to 12 months. So they've been very explicit in terms of outlining the significant penalties that can occur if people are conducting activities that may not be appropriate around the JobKeeper payment. So although they look like they're things that could apply on the fringes, I would just highlight that, as per the previous slide, the false or misleading threshold is not a very high threshold, and so people need to be very mindful and careful around claims that are being made under JobKeeper provisions. Okay, so we're coming towards the end of the presentation, and just as a final slide, I mean, that's all a lot of technical information on how the provisions apply, and we provide a lot of references to where the information is contained in the rules, and how we believe some of those provisions will apply. As I mentioned, a lot of it is currently still a little bit uncertain. You know, they only came out yesterday, and we don't have any explanatory material. We only have them in draft, so they could change and could become final. But unfortunately, we are sitting in April, and the first fortnight finishes on Sunday, and so people need to start acting now and need to start doing things now. And there's quite a lot to be doing over the next coming weeks. And I'm just going to highlight what I think are some of the key things that everyone needs to be thinking of and should be trying to action as soon as possible. Firstly, one of the key things here is that you need to pay your employees the amount and report those to the ATO. And as I mentioned, it's likely that's going to be through single touch payroll, but you need to be aware of how your system might be looking to do this and how it might report it. So I understand that Xero and MIB are integrating their system to be compliant. If you use a different system, you should be checking with them to see how that is going to be managed and how you may be reporting this information to the ATO. So see what they're doing around their systems. Secondly, obviously, we're in April, and there's a lot of information to go through there, projections, other things to do. The cutoff date that you should be working to, obviously, is the 26th of April in terms of what we believe to be the period that you're going to get extensions to understand how everything's working. Noting again that Sunday is the finalisation of the first fortnight. So that is not far from now, 26th of April. Not a lot of time to try and get everything in order and trying to check your position and understand what that otherwise means for you. So it is really ensuring that you're going to be in a position to understand that by the required dates. In order to do your turnover calc, you need to get your GST turnover calculations correct for comparison periods. So pulling out each of those months and each of those quarters for comparison periods, we're talking about April, May, June, July, August, September. Those are the months you need to focus on. If you're in a GST group, you need to start splitting those out. If you've got multiple suppliers in there, so GST taxable, GST free, and input tax, you need to make sure that you've got those coded right and just split those out and that you've got them all for those comparative periods for the relevant entity that you're looking at. Critically, it's all going to come down to projected GST turnover. So having an appropriate budget that is compliant with the ATO's ruling in terms of GSTR 2001-7, ensuring that what you're doing is acceptable for your projections and that it's a bona fide estimate of what your projections are is going to be critical in terms of doing that 30% comparison. And for many businesses, it's going to be a lay down in terms of they will already know they're way under 30%. But for those that are on the fringes, that are close to 30%, this is where it's going to be absolutely essential. Going through the eligibility test for employer is one of the tests that you'd have to be working through. Again, most of the tests are very easy to work through. The really important one is the turnover test. The remaining tests you should be able to work through quite easily. However, the one thing that businesses need to also grasp is this wage payment requirement, where you need to pay the the excess amount or the payment amount to your employees by the relevant fortnight. Now, there was one thing I didn't mention is there is an exception if you have a different payment cycle, that the Commissioner may provide some rules on how to allocate the payment cycle. So if you're paid on a monthly basis, how that can therefore be allocated to 2 fortnights. But outside of that, businesses will need to understand what they need to pay if they elect into this regime, and they are going to get notifications from employees, how many employees are going to opt in to applying for this JobKeeper payment, and what that will mean for short-term funding in terms of funding that, whether you need to fund payments that you otherwise wouldn't have made. You'd also need to ensure that you're aware of all of the documentation that you need and what nominations and forms need to be submitted to the ATO. As I mentioned, if you don't get an election to be a part of the scheme in by the relevant end of the fortnight, you may miss out for that fortnight. So it's ensuring that you exactly understand which forms need to be completed and submitted with the ATO on the relevant time. And finally, and one of the most important, is please be aware of the integrity provisions, all of the integrity provisions, in terms of if you are doing anything or adjusting anything or changing any legal agreements or looking at your relationships with other parties in the group, you just need to be mindful of the integrity provisions and whether they may apply to your circumstances due to the significant penalties that may otherwise be attached to those provisions. Okay, so those are the action items that that we believe, at the very minimum, people should be thinking about, should be looking at in terms of the JobKeeper payments. Now, that's basically that's basically the end of the presentation. Now, I'm just going to turn to my team to see if there's been any critical questions that they've seen that I should be responding to before I close out of the presentation. So I've just got the response back that we have had an overwhelming number of questions, and it's been very difficult for the team to get through all of the questions that have been raised and to identify which ones have been important questions to answer over this, or which ones I haven't otherwise addressed during the session. As I mentioned, we will be collating all of the questions. We have access to all of the questions that have been raised. There's a number of them that are duplicate questions. We will put those all together and we'll look to try and provide a response to those as soon as possible. We will likely try and place the responses up on the web page in terms of what we believe the answers may otherwise be to those questions. We do have a website that has an FAQ, which is a number of questions that have been raised to date, where we've provided responses prior to the release of the rules. We are in the process of updating that. We'll look to add these questions to that and provide a response over the next number of days. Again, if you do need to speak to someone, by all means, reach out to a Pitcher Partners person, your contact, and you should be able to have a conversation with them and obtain further information in relation to the operation of the JobKeeper payments. At the end of this, I just want to say thank you for everyone for attending the session. I do wish you all the best during this period in terms of this very harsh period. I do wish you all the very best. Again, please contact us if you need any help or require any assistance around the JobKeeper provisions. Thank you once again.